In the days leading up to Prince Harry's return to a London courtroom, the public conversation has taken an unexpected turn, one that, depending on who you ask, is either harmless distraction or calculated diversion. Commentators and online observers alike have begun to question whether a newly resurfaced video of Meghan dancing with Prince Harry inside their California home is quite as innocent as it appears. Supporters describe the clip as playful, relaxed, and intimate, a private moment between a husband and wife, casually recorded, never meant to be scrutinized. Yet almost as soon as it began circulating, doubts followed. Viewers began asking uncomfortable questions. When was it filmed? Why was it released now? And perhaps most pointedly, who decided this moment should suddenly be shared with the world? To some, the timing feels off. Too convenient. The video's appearance coincides almost exactly with troubling developments in Harry's ongoing legal battle against Associated Newspapers Limited, publisher of the Daily Mail and Mail on Sunday. As legal pressure intensifies, so too has speculation that the video may function as a smoke screen, a carefully placed distraction designed to soften headlines and redirect attention away from courtroom complications. Not everyone agrees. Many dismiss the conversation as typical internet overreach, the kind of conspiracy-laced chatter that follows public figures wherever they go. But others aren't so quick to brush it aside, particularly given what is unfolding behind the scenes of one of the most high-profile media lawsuits in recent British history. Prince Harry is not alone in this legal fight. He stands alongside a roster of prominent claimants, including Sir Elton John, all alleging that Associated Newspapers engaged in unlawful information-gathering practices. The accusations are serious, touching on privacy violations, illegal surveillance, and unethical journalistic conduct. Unsurprisingly, the publisher has firmly denied all claims. The case already carried weight due to the names involved and Harry's long-standing public crusade against press intrusion. But in recent days, the situation has taken a dramatic and potentially damaging turn, one that could complicate the claimant's position considerably. According to reports from major outlets such as The Telegraph and Reuters, a private investigator named Gavin Burrows, previously linked to evidence relied upon by the claimants, has made an explosive assertion. Burrows has reportedly told the court that a witness statement attributed to him was not, in fact, written or approved by him at all. Even more troubling, he claims the document was prepared by others without his knowledge, contains significant falsehoods, and bears a forged signature. If accurate, these allegations strike at the heart of the case. In legal proceedings of this nature, credibility is everything. Evidence does not simply support arguments, it is the argument. A single disputed document can ripple outward, casting doubt on surrounding testimony, weakening legal strategy, and inviting intense scrutiny from both the court and opposing counsel. That said, it is essential to emphasize what is known and what is not. These claims remain allegations raised within ongoing proceedings. They have not been proven as fact. They will be tested, challenged, and examined through the legal process, as they should be. Courts are built precisely for moments like this. Still, the seriousness of the accusations cannot be ignored. Reports suggest that during hearings, accusations of dishonesty, fraud, and even conspiracy were raised in connection with the contested statement. These are not minor procedural disputes. If substantiated, they could pose a significant problem for the claimant's case. Adding another layer of tension, Burrows has reportedly expressed fear for his personal safety. According to coverage of the hearing, he requested permission to give evidence remotely, citing an alleged attempt to intimidate him shortly before the trial began. Once again, no wrongdoing has been publicly confirmed by the court, but the claim itself adds to an already volatile atmosphere. Separately, The Times reported that Burrows was contacted by a journalist from Byline Times, a detail that was referenced during proceedings. Online commentators quickly seized on this point, suggesting it raises questions about broader media relationships and legal coordination surrounding the case. As with much else in this story, interpretation has raced ahead of confirmation. Speculation, however, is not proof, and it bears repeating that much of the online commentary remains exactly that, speculation. Yet when legal battles, media narratives, and personal reputations intersect, perception alone can carry real consequences. As Prince Harry prepares to return to London for the High Court hearings, attention has also turned, once again, to the state of his relationship with the royal family. Despite public curiosity, no formal meetings have been announced. Reports indicate that the Prince and Princess of Wales will be in Scotland for engagements in Stirling on January 20th, placing them away from London during Harry's court appearance. King Charles and Queen Camilla are also expected to be in Scotland during this period. If accurate, these schedules would make any face-to-face reunion unlikely, at least publicly or officially. While some observers speculate about private encounters, there is currently no confirmation either way. What is clear is that Harry's return to the UK appears set to be dominated entirely by legal matters once again. If present reports hold true, his visit may pass without any visible contact with senior members of the royal family before he returns to the United States, and hovering over all of this is a stark reality. If allegations of forged evidence or fraudulent documentation were ever proven, the implications would be severe. Forgery and fraud are not technical errors, they are criminal matters. Such findings could seriously undermine the credibility of the case and damage Harry's broader campaign against media misconduct. But for now, facts remain facts, and allegations remain allegations. No final determinations have been made. The court will decide what is credible, what is admissible, and what holds weight. Still, the optics are difficult to ignore. At a moment when legal focus should be razor-sharp, distractions, intentional or otherwise, have filled the public space. Whether the dancing video is coincidence, misjudgment, or strategy remains unknown. What is known is that Prince Harry's legal fight has entered a far more complicated and precarious phase, and as the courtroom drama unfolds, one thing is certain: the outcome will not be shaped by social media sentiment or viral clips, but by evidence, credibility, and the unforgiving scrutiny of the law. As the legal storm surrounding Prince Harry intensifies, the focus has shifted from allegations against the press to something far more dangerous for any claimant in a courtroom: credibility. In cases built on testimony, documents, and historical patterns of conduct, even the suggestion that evidence may be compromised can send shockwaves through the entire legal structure. And that is precisely what now appears to be happening. The reported witness U-turn has not simply added drama to the proceedings, it has changed the temperature of the case. What was once framed primarily as a moral and legal battle against media intrusion is now, at least temporarily, clouded by questions about process, documentation, and trust. Courts do not operate on vibes, public sympathy, or long-standing grievances. They operate on proof. Clean chains of evidence. Clear authorship. Verified statements. This is where the problem lies. If a witness whose name is attached to key material now claims that material was produced without his knowledge, or worse, signed without consent, the court cannot simply brush that aside. Judges are trained to be suspicious of anything that appears irregular, especially in cases already under intense public and political scrutiny. Even if the core allegations against the publisher were entirely legitimate, doubts around one piece of evidence can open the door for defense lawyers to challenge the reliability of everything else connected to it, and defense teams rarely miss such an opportunity. From a strategic standpoint, this development is a gift to Associated Newspapers' legal counsel. It allows them to pivot the narrative away from alleged historic wrongdoing and toward the conduct of the claimants themselves. Instead of answering accusations, they can ask questions. Who prepared this statement? Why? Under what circumstances? And if mistakes or misconduct occurred here, where else might similar issues exist? This is how cases are weakened, not always by disproving the original claim, but by eroding confidence in the people bringing it. Outside the courtroom, the damage may already be spreading faster than any legal clarification can contain. Public opinion, especially online, does not wait for verdicts. It reacts instantly, emotionally, and often brutally. The phrase "forged statement," even when unproven, carries enormous weight. Once it enters the public bloodstream, it reshapes perception. Headlines shift. Tone changes. Doubt creeps in, and doubt is deadly in a narrative-driven campaign. Prince Harry's long-running public stance against the media has been rooted in moral clarity. He has positioned himself as someone fighting not just for personal justice, but for broader accountability. That framing depends on one key assumption: that his side operates cleanly, transparently, and above reproach. Any suggestion, fair or unfair, that corners were cut undermines that moral high ground. This is why timing matters. The resurfaced video of Meghan and Harry dancing, released just as these legal complications emerged, has fueled suspicion, whether justified or not. In isolation, the clip is harmless. But communication is rarely judged in isolation. Context defines interpretation. When light-hearted content appears at moments of legal vulnerability, critics interpret it not as coincidence but as strategy. Whether that interpretation is accurate is almost beside the point. The perception alone creates friction. This is not new territory for Harry and Meghan. Since stepping back from royal duties, they have faced repeated accusations, some legitimate, some exaggerated, of attempting to control narratives, shift focus, and manage public attention aggressively. Each new controversy adds another layer to that reputation, making future explanations harder to accept at face value. Meanwhile, the absence of any visible royal family interaction during Harry's UK visit quietly reinforces another narrative: isolation. With senior royals reportedly in Scotland and no meetings announced, the image presented, intentionally or not, is of a prince returning to his homeland not as a family member, but as a litigant. Alone. Surrounded by lawyers rather than relatives. Defined not by duty or reconciliation, but by court schedules and legal briefs. That symbolism matters, particularly in Britain. It reinforces the sense that Harry's relationship with the institution he once represented has fully transformed into something adversarial, transactional, and distant. For supporters, this underscores his independence. For critics, it confirms their belief that bridges have been burned beyond repair. The legal risks, however, extend beyond symbolism. If allegations of forged or misleading evidence were ever substantiated, even partially, the consequences could be severe. Courts take such matters extremely seriously. At minimum, it could weaken the current case. At worst, it could expose those involved to further legal scrutiny. This is why most legal teams are obsessive about documentation. One mistake can eclipse years of careful preparation. That said, it must be stressed again, none of this has been proven. Courts exist precisely to separate fact from assumption. Witnesses are cross-examined. Claims are tested. Evidence is verified or rejected. Many dramatic allegations collapse under scrutiny. Others survive stronger than before, but even if the claims ultimately fail, the process itself exacts a cost. Public trust is fragile. Once shaken, it is difficult to restore fully. Every delay, contradiction, or reversal chips away at confidence, not just in a single case, but in the broader campaign Harry has waged against the media. Opponents will argue that this moment exposes hypocrisy. Supporters will argue it reflects the chaos of fighting powerful institutions. Both interpretations will circulate simultaneously. What is undeniable is that Prince Harry now faces one of the most challenging phases of his legal battle. Not because of the original allegations, but because the spotlight has shifted inward. From what the media allegedly did, to how the case itself has been constructed. As the hearings continue, the court will decide what survives scrutiny and what does not. Until then, speculation will continue to fill the gaps left by silence and legal confidentiality. The truth, whatever it may be, will emerge slowly, methodically, and without regard for public opinion. For now, one thing is clear: this is not the clean, straightforward confrontation Prince Harry likely hoped for. It is messier, riskier, and far more consequential. And depending on how the evidence issue unfolds, it could mark a turning point, not just in this case, but in how his entire media crusade is perceived going forward. Whether this moment proves to be a temporary setback or a lasting blow remains to be seen. But as of now, the ground beneath Harry's case looks less stable than it did just days ago, and in court, stability is everything.